attorney practicing with me. I have my son Charlie, who strives to be an attorney practicing with me one day. To do. As the risk grows greater, so does the duty, because the risk to be perceived defines the duty that must be undertaken. A recognizable legal duty was pleaded in the plaintiff's complaint. The duty of a physician in informed consent cases is established by the accepted standard of medical practice among members of the medical profession with similar training and experience in the same or similar
statute.
Yes, sir.
Right. The statute. There's
1.766.103.
So you right now, I just want to make sure everyone's on the same page. What we're confined to the informed consent, not the only remaining theory, at least for the purposes of appeal, is failure to informed consent.
Yes, sir. That's the only issue.
And so the way I'll just cut to the chase, or my chase. The subsection A doesn't include any substance. In other words, what information needs to be included.
Correct.
And yes, subsection A does direct the attention to an accepted standard of medical practice, but that is in obtaining the consent. And the way I read that, or one way of reading it for the sake of our discussion this morning, is the standard medical practice of obtaining the consent. Right? So what about the standard medical practice of obtaining the consent was wrong?
Yes, sir.
Not the information.
Correct.
It seems you're directing towards the information, which is.
You're talking about the form itself, as far as
That's right.
obtaining the information.
Yeah. So the standard of medical practice of obtaining the consent is to be measured against the acceptable standard of medical practice among members of the medical profession. But you've confined your theory to the information included in that.
Yes, sir.
Information informed.
We have no problem with the form.
Right. So subsection 2 of A says that the information is described in terms of the risks or hazards inherent in the proposed treatment. So is the experience level of the physician a hazard inherent in the proposed treatment?
Sometimes it is, Your Honor. If you look at the statute, that section that you just talked about, you'll see the language in section 2, the first sentence. I won't read the whole part of it, but it says under the circumstances. So we're talking about each case circumstantially in what's discussed as to the inherent risks and hazards, the substantial risks and inherent hazards in each situation. So section 2 of the statute.
Circumstances, where he said under the circumstances. Okay.
Under the circumstances, and also
under the circumstances, the individual on the procedures form would have a general understanding of the risks inherent in the proposed treatment.
correct, Your Honor, and that's right where we're at.
Okay.
Under the circumstances of this case, we're not asking for a bright line here today. There is no bright line. You can't have a bright line. What we're asking,
What did you say? You can't have a what?
you can't have a bright line.
Oh, bright line, okay.
Like they're gonna come up here and they're gonna say, not to make their argument for, they're very capable, but they're gonna say, you know, that this is the statute, he gave the risks, he gave the inherent risks and the substantial problems that you might have, and that's it.
What you're saying is one more risk. If this is your first time you're using a robot, there's a risk in using that robot, something may go haywire, but you gotta tell me about it. You just can't tell me what the risk of using a robot in general. You can't separate the robot from the operator.
Correct.
And the court said the operator doesn't have a duty to disclose it's his first surgery. because that's part of the umbrella of medical malpractice.
That's absolutely correct, Your Honor. She said there was no explicit duty. This was the Friday before trial in a case that had been litigated for a number of years.
And she went against the expert affidavit that was
Yes.
attached.
In
Okay,
fact,
and
I'm
and
sorry,
so on
Judge,
a
I didn't mean
judge-
to interrupt.
So on a judgment on pleadings, in this case, and I'm not so sure I see that in every case, where the expert affidavit is actually attached to the complaint.
You don't see it very often. I do it as a matter of course because I've done this for 37 years and I learned my lesson.
So you're saying that the conflict, because the expert affidavit actually stated what the legal duty was, that she shouldn't have been able to go against what the pleadings.
That's it.
So incorporating the affidavit, the duty was, that's an allegation, it's an affidavit, but it is an allegation because we're at the pleading stage, right? The allegation is that there is a duty under the statute to inform the patient about how many of this type of procedure the doctor is.
In this particular circumstance,
So my question is this, so that affidavit, correct me if I'm wrong, my memory fades quickly, was essentially, I mean, it's kind of a hybrid here, right? It's evidence. We'll treat it as an affidavit, but let me treat this affidavit as an allegation, so we're at the pleading stage and it's incorporated, and that's your theory, I guess, right? So the allegation is that it is an accepted standard of medical practice to inform a patient of how many procedures a doctor has performed.
in this particular
The problem with
instance,
that is accepted medical standard medical practice is in subsection A1. And subsection A1 is the section that describes the action in obtaining the consent, not the information that is to be provided in obtaining that consent, right? So where in subsection 2 does it allow the litigant, the plaintiff, to create a duty out of thin air and have it be, a state claim for a cause of action under this section to say that there was a duty to say how many of the procedures.
that's established by the medical testimony of the doctor.
That's testimony, but you have to fit it into the, what was that affidavit? It said, hey, this is the general, everybody's doing this. This is the way all the doctors do this. But that doesn't make it a risk inherent in the procedure, just because some affidavit says it's a risk inherent in the procedure.
No, I agree with that, Your Honor. That doesn't make it a risk. Just the mere affidavit, you have to have a legal duty. And the duty is set.
And this is a statutory duty.
This is a statutory duty, but it must be, the language within the statute must be given some credence. You have to.
Which
follow
language?
The language under the circumstances. And we're following
Under some circumstances, you need to tell them about these risks and hazards inherent in the procedure. In other circumstances, you need to talk about these risks and hazards inherent in the procedure. But under no circumstances would you need to talk about something that is not a risk or hazard inherent in the procedure. So if this is not a risk or hazard inherent in the procedure, proposed treatment, then if it's not of a type, that's a type of information. And under the circumstances, which of that type of information must be described? If we decide, and if they convince us that that is not of the type of information required to be provided to the patient by statute, which is to say it's not a risk or inherent in the proposed treatment or procedure, then under no circumstances is there a duty to provide it. Are they correct or incorrect?
Well, the statute says that the doctor must tell the patient about the substantial risks and inherent problems that may be encountered. And in this particular case, the doctor said certain percentages. Now, these are the percentages with regards to urinary incontinence and erectile dysfunction. One was 30%, one was 10%. So the overall chances is that you could wind up with both, which my client did, is 3% if you do the math. So that's essentially what the doctor, under paragraph B of the statute, was duly obligated legally to give to my client, Mr. Yentes. He did that. We don't question any of that. And it's clear that he has a duty, Your Honor, under this part of the statute to give that information. And the case law that's come out from this district, actually the case law that has come out in the state of Florida is mostly from the Second District Court of Appeals on this issue. Pretty proud of that. And
Well, you got the affidavit attached to the complaint, correct?
yes, Your Honor.
The affidavit says the first time using a robot, you gotta tell the patient.
I won't say that it says all that, I have it, but it basically supports the case in that he should have, and there's also testimony from the doctor, the expert, Dr. Levin, who said that if you take a 5.5-year hiatus, or whatever you want to call it, he stepped away from the practice of robotics for some period of time. If you go into one of our pleadings, I think it was our reply to the answer, we have a picture of the type of robot that is being used here. This is not just a simple device. Take a look at the picture, please, because it's an extensive device and it's not something that you get into and you put your hands into and you look through a screen. This is not something that's done every day.
The skill of the operator is different from operator to operator.
Correct.
They can't all be the same.
It can't all be the same. And what you have, Your Honors, is there's doctors out here that are doing this right now. They do it, they are specialists at it. If you go like to the Mayo Clinic or some of the other better institutions, or even not, just, you know, even here in the, I promise it's being done within a 100-mile radius right now. What they do, you have specialists that do this on a day in and day out basis. So they're doing this, and it's just, it's like science, it's just science, it really is to them. It's an assembly line.
You acknowledged, I mean, you acknowledged probably your briefs too, but you just acknowledged that certain hazards,
Correct.
the exact type of hazards that were mentioned in the information provided to obtain consent were the type of hazards that unfortunately befell the client, right? So that's established. They did convey to the patient information that included hazards that, again, unfortunately, were the ones that for which you're trying to recover. So I can, and then you mentioned percentages. I can see, and I'm playing devil's advocate, as everyone in here probably recognizes I do. So you mentioned percentages. So I'm not saying this would state a cause of action, it wouldn't, but it'd be one thing if you said, well, if I allege that the information conveyed to the patient was that it was a 3% chance of incontinence. But actually, because this doctor didn't perform them frequently enough, it should have been a 50% chance.
Yes, sir.
But you're not saying that, you're saying that you have to tell the patient how many times this doctor has performed treatment.
Well, I think what we're saying here, Your Honor, is that at some point in time in that discussion, when you sit down, when he sat down with Mr. Yentes, who was in his late 70s at the time, he should have had this discussion with him, that he should have not only gone over the risk that you and I just discussed out of the statute to comply with the textbook of the statute, but at some point in time, a reasonable person, a reasonable patient, and we would submit a reasonable doctor, supported by Dr. Levin, would have said, look, I haven't done this for a while. In fact, it's been 5.5 years, and that's going to increase those risks that I just told you about. That's going to increase the percentage of the erectile dysfunction. What Dr. Papadopoulos gave was essentially information that covers that. Those are statistics based upon the doctors that are doing this day in and day out.
Well, what if the doctor thinks that, what if the doctor already factored in the fact that he was a little rusty? Presuming that that's the way.
Well, based on the testimony he did, and based upon.
Well, I'm not talking about the
he did not
testimony,
either.
right? I'm not talking about testimony yet.
Yes,
I never
We're talking
want to
about
interrupt you.
pleadings.
Can I just let them know you have 5 minutes? Did you want that for rebuttal?
I'd like that for
Or do you
rebuttal.
want to finish your answer or say?
I'm happy to answer the question.
Go ahead. Yeah, go ahead.
I'm gonna have to hear it again, I'm sorry.
Well, I'm saying, well, I mean, on the face of the pleadings, your complaint, your allegations, your cause of action is riding on
And that's established by,
But my point is, but you said, well, and one of your arguments or one we're discussing is, well, that would increase the percentage. But why on the face of the complaint? I mean, the doctor might very well have said the percentage is 3% because even though I haven't done it in a while, I'm really good at it.
it's axiomatic. It's axiomatic that the more you do of these, and it's supported by the medical literature, the better you get.
All right, if you stop now, I'll save you the
Yes, sir.
5 minutes, okay? All right, thank you. All right, gentlemen on the other side, ready to roll?
Yes,
Are you all you're doing the full 20 or is there a division here?
no, I'll do the full 20.
Pardon me?
I will do the full 20.
Full 20, all right, sir. Go.
May it please the court, my name is Joe Justice, and I stand to represent the appellee. My firm represents Dr. Papadopoulos. This really is more of a doctor issue than a hospital issue, which is why I'll be presenting the appellee's position here. And obviously, our position is that the trial court got this right, and that judgment on the pleadings was appropriate because there is no duty under Florida law to provide a disclosure to a patient for the doctor to do so about their own experience with a specific procedure. And that's what this case comes down to.
Whether it involves a robot or not, because that's new technology, correct?
Well, I suppose it means on how you ask that. It's not that in that we know there was a hiatus of about 4.5 years. Prior to that 4.5 years, Dr. Papadopoulos, the record shows, had done 84 of these types of robotic prostatectomies while training at the Mayo Clinic. So it's not that new. And certainly prostatectomies aren't that new.
What's your best case that says there's no duty to disclose experience in the procedure?
I think the answer to that is the fact that there's no case that says that it is obligated.
But don't the cases say that it depends on the particular case and the facts and circumstances of the case of what the informed consent should be? And isn't this really what we're talking about? Isn't this really better for a summary judgment? I mean, because here the court disregarded an expert affidavit that's required to set forth what the legal duty is. And the legal duty is consistent with what the complaint allegations were. And she went against the grain of that. But the cases talk about it's the particular facts of the case. So I'm trying to get over that. So help me out.
I will, and I disagree in this respect. There's a difference between what the allegation is or what the affidavit says and what the statute says the duty is. The doctor doesn't set the duty. The doctor, under the statute, would have to provide the trial court with an opinion as to how do you accomplish this, not what do you need to tell. The categories of the information that the doctor must provide, that's set by the Florida legislature under 766.103. I guess that's 3A2. And that section says this is the information that needs to be given. It's the type of information that will be necessary to impart on a reasonable person a general understanding of the procedures, that's the procedure itself, in this case, robotic prostatectomy, medically acceptable alternative procedures or treatments. So is there something else? And that could also include what the case law tells us, presumably not doing it at all, which is probably not a good option in a case where this is a cancer treatment that if you do it, you live, if you don't, you probably don't. And then the substantial risks and hazards inherent in the proposed procedure. And that is precisely what, well, so from a pleading
And so you have to
perspective,
go outside the statute to determine what that is, right? What the substantial risks are. I mean, how can, we can't just look at that and know what that means.
well, that's what the first.
That's why we need expert affidavits, right?
Well, you need expert testimony.
Yeah, and then come summary judgment, you would have your own expert that would counter and say completely opposite what the substantial risks were, because I can't by the statute know that.
That would assume that there was a duty in the first place. And that's the distinction that I'm trying to express to the court. this is like, so if we take this, remember, this began as a garden variety medical malpractice case and informed consent case. The original complaint says it contains both of those. Through the course of discovery, it became clear that the appellant's expert does not believe there was any negligence here. He did not offer opinions that said, hey, he breached the standard of care. So if we take that piece of it and say, should we move for summary judgment, would that be appropriate? Yes, because although the doctor doesn't set the standard of care, he comes in, or doesn't set rather the duty, which is to satisfy the standard of care, he's the one who would have to come in and say that it wasn't breached. They weren't able to do that. So we could have moved for summary judgment there. Now, juxtapose that with the informed consent claim. Under informed consent, first of all, you don't have to prove negligence. You don't have to prove the level of causation you have to in an ordinary medical malpractice case. You have to prove that, some risk wasn't told to the patient, and a reasonable patient might not do this if they had known that, even though he did everything right otherwise, which is what we have here. But what becomes important is, what is the information that must be given? The expert doesn't create the duty, the expert explains the duty. And so if you look at what the statute would require, Your Honor is correct. You can't look at the statute and say, what is it we need to tell a person who's about to have a prostatectomy? Because the statute doesn't say, hey, a certain percentage of you, no matter how good we are going to wind up with erectile dysfunction and incontinence. The statute doesn't say that. Dr. Levin, who was the appellant's expert, could come in and say, hey, you needed to tell them that if we had evidence that that hadn't been told to the patient. It was. That's why we're not here talking about whether or not the patient was informed of the risks of the procedure. We're talking about something that is not found in any case in the state of Florida. No case in the state of Florida has said that the experience of the doctor.
Or either side has no case.
Correct.
So what, I guess my obvious question is, I'm going in for brain surgery, and I've got a great brain surgeon. And this is gonna be his first case in 4.5 years where he's using little tiny microscopes on my veins. He doesn't tell me that. You think I would be worried if he didn't tell me that? Does he have a duty to tell me that? Or is it a jury question? Or I have a bunch of experts say he should have told you that. They have experts say it doesn't matter. He still did everything right. It's just he used a different device. I mean, I'm just confused why there's no case law. That would be nice if there was. We'd both be happier. We'd be happier. But if there's no case law, there's got to be something in the United States of America somewhere, somehow, in some state of the union that would give us the answer.
And there is. And the appellant cited to it in their initial brief. And what they did is they cited to a law review article from the University of Illinois.
Does it have any cases in it, or just?
Well, it has a canvas of cases across the country. And the language, and this is really key, the language of this, after this canvas is done by this author, the conclusion is, and remember, just to make the point, they're arguing for a change in the statute.
They're arguing why?
They're arguing for a change, that's what they're arguing.
Okay,
And their finding is that the vast majority of courts reject the notion that informed consent requires affirmative disclosure of physician experience or qualifications on the grounds that only information about the proposed treatment itself qualifies as material. So there, across the United States, yes, the vast majority of the states have done what we are saying Florida does, which is that isn't one of the issues, and it makes sense.
but I mean, that's the nub for us to figure out today. Is there more to this case than what you both said?
There's no, but to understand the ramifications of it, right? And why it makes sense that the statute says what it says, and our explanation of what it means, and what all the cases in Florida thus far have found is the right application. It's that it creates an objective standard for the doctor to know what do I need to tell the patient when they come in. Because we can tell you X percentage of these will have this outcome. We can tell you if you have a specific physiological problem, like we saw in the Santa Lucia case, which came out of this court, that increases your specific risk for intubation. That was what it was in that case. We can tell you that. What we can't tell you is, and even their own expert, the appellant's expert said, I can't tell you that there's any actual additive risk from Dr. Papadopoulos, who's had a 4.5-year hiatus using a robot versus.
Well, we're not there yet. That's just theoretical, because that's jumping ahead to evidentiary matters. But let me ask you this. So you're just saying that, which they acknowledge that the doctor, the hospital, whoever, mentioned the hazards attended to, in general, the proposed treatment, right? But, and I am speaking with opposing counsel, focused on the words inherent in and the type of risks, right? But what about the phrase, the proposed treatment or procedures? So doesn't that have to be defined under the circumstances? In other words, there's risks and hazards inherent in the proposed treatment generally, but wouldn't the risks and hazards inherent in the proposed treatment by a doctor doing it for the first time be different from the risks and hazards inherent in the procedure, the proposed treatment performed by a doctor who's performed them every day for 20 years? I mean, isn't that a different proposed treatment? In other words, yes, risks and hazards inherent in must mean the type of treatment, but isn't it permissible reading to say the proposed treatment by an experienced doctor is a different proposed treatment than by a new doctor? And therefore the risks inherent are different for each.
No, and the reason is because what the statute is telling us is that the risks that are the same from this procedure, regardless of who performs it and regardless of who the patient.
You're just saying you have to average it all out, right? You're just saying in the aggregate, in the average, you know, it might be more, and I don't want to talk about what the experts said, you know, maybe you would win like Judge Smith said at summary judgment because the expert said, nope, there's no additive risk. But let's just say that, let's leave that aside. You're just saying in the aggregate, yeah, when averaged from the guy who performs it when he's a resident for the first time and the gal who performed it for the 200th time in her 10th year as a surgeon, in the aggregate, it all averages out to 3% chance that you're going to get incontinent from this. But isn't it possible to read the statute to say that's a different proposed treatment, the resident who's doing it for the first time, and the experienced surgeon who's done it 20 times? Is that a permissible reading of the words proposed treatment?
No, if that's what the legislature wanted, that's what the legislature told us. Proposed treatment or proposed procedure, because it's a phrase, is talking about the procedure itself. And those are the risks that don't change from practitioner to practitioner and patient to patient. The only thing that the case law has sort of added to that, and it certainly makes sense, is if you've got a patient like in the Santa Lucia case that's got some specific issue that might cause them to have a different level of risk. Because again, that's not going to change from hospital to hospital, state to state, practitioner to practitioner.
Do you have a case that says that it doesn't change from practitioner to practitioner? Or does the statute doesn't say that?
I'm not sure if I understand the question. Go ahead.
Okay, you just stated that the proposed risk of the procedure doesn't change from practitioner to practitioner. Do you have a case that says that?
Well, that would be more of a fact issue than a case issue. It's the point.
Isn't that kind of the point here?
Well, no.
On judgment of,
Yes and no.
okay, so
Okay.
how do I rely on that if I don't have a case? You don't have a case that helps me with that.
Well, the point to the statement was that what is required and what we see across the country is that when you have, as we have here, and I know we were trying to stay outside the record, but I think it is important to understand the ramifications. You've got a known stated risk, no matter who does this, we do have this in the record, no matter who does this procedure. According to the appellant's expert, there's a percentage of people who will have the exact two complications that occur. No matter what, the best person in the world, the Dr. Levin said is, I can't tell you that the experience that occurred, the inexperience or gap in experience.
But is that because we don't know what those stats are and they weren't in the data? I mean, aren't the stats as only good as the data?
But that's important because all what we're gonna do here, that this court put out a case long ago called Thomas versus Variance, which talks about balancing the interest between how do we inform and how do we not scare the patient out of a treatment that they need to have, right? And in that case, one of the issues certainly that comes out of that balancing is we don't want to confuse the patient either. And right now, what we know is we can tell them, because we have great statistics, you have this procedure, you have a chance of this. Well, what no one can tell them, at least called an appellant's expert in this case, is that having done open procedures for 4.5 years, having had a gap using a robot, then going back to Mayo Clinic to have a refresher course, and then resuming using this particular tool to do the same procedure you've been doing, somehow changes the risk. We don't have data for that. So you run the risk of confusing the patients. So that's one of the issues.
And is there a case that says that?
That we run the risk of confusing the patients.
Yeah, the purpose of the statute and why it should be construed narrowly to only what you're telling us it should be.
No, Your Honor, what I would tell you is that all of the cases that we've been able to find on both sides of this talk about procedure specific. You've got procedure specific issues for the possibility of an ectopic pregnancy after a tubal ligation. You've got procedure specific.
Why don't you just tell her the answer is no? There's no case that says it. But again, we understand that. That's frustrating for everybody.
Well, I think it's more than frustrating for everybody. I think what it goes to is that the appellant's asking you to change the duty, trying to ask you to expand the duty beyond what the
But
statute
wait a
says.
second, no, I mean, we're here on a motion for judgment on the pleadings. We are not here, we're not being asked to determine the duty. We're just saying that it may be procedurally in the instance that we have an expert, at least from my standpoint, I certainly don't speak for everybody here, perhaps, but if there's an expert affidavit that explains what the legal duty is, for the trial court to disregard that, this isn't a case then that should have been decided on a judgment on the pleadings. So we're not here to determine the legal duty. I think that would go beyond what this appeal is.
Okay, then I will retract that, but what I would then say is, our position is that the expert doesn't create the duty, the statute does. And so the expert would then be the one who may come in and explain how or whether that duty was breached, not unlike on the garden variety type of claim. But the expert, you can allege lots of things in the complaint that doesn't create a duty. The question is, what was the duty in the first place? Their position is that the statute says that an individual doctor's specific experience with a procedure is within the inherent risks, or I think the way they say it, the circumstances.
Because,
That
well, then
means-
what does that mean if it's not under the particular circumstances of the case? Do we do ignore that?
Oh, no, that has a meaning, and that meaning is the circumstances of the case, which is, I've got, a man that has this type of prostate cancer. It's, this level, or, this staging, these are the different ways that you can handle that. These are the sort of risks that would be posed by that procedure when performing this type, and those are the circumstances of the case or of the procedure.
You're saying under any circumstances, the phrase inherent in the proposed treatment cannot mean inherent in the doctor. In other words, the procedure is the procedure is the procedure. And there are certain risks inherent, like if this is done to you, this might happen. That's a risk or a hazard, right?
Yes, and that's exactly the position. And what the argument being made by appellant is really a McCain type of argument, which is you create a foreseeable zone of risk, you have to take the reasonable precaution.
Can you have a cause of action based on a miscalculation of the percentage of risk? In other words, I can imagine, given who your client is, what side of the V you're on right now, that you would say that the substantial, I don't want to answer the question for you. If you said, if you get brain surgery, you could bust a blood vessel and have an aneurysm, that is a risk or a hazard. And if you said, I think you got like a 97% chance that won't happen. Could you sustain a cause of action for, under this statute for, based on, lack of informed consent because the information was incorrect, meaning, yeah, you know what, actually, this happens, actually 9 out of 10 people have an aneurysm and die if they do this.
Yeah, that, Your Honor, would come under one of two places. One would be subpart A1, that it didn't fit within the accepted standard of medical practice. Well, certainly accepted standard of medical practice would be to get the information right, or at least as close as you could.
Mr. Joseph, you're out of time, but I'll give you 30 seconds to wrap up.
Okay, and then I presumably could come under the circumstances. Well, the answer is, if we're talking about the procedure itself, yes, but if we're talking about experience, that's a subjective ad hoc type of setup that is not what is envisioned by the language of the statute.
All right. Thank you very much.
Thank you.
Mr. Franz, I said I'd give you 5 minutes and you have 5 minutes.
Thank you.
Let me ask you a wrap-up question that you can rephrase this and keep going with your regular thoughts. I'll start the clock there. We need to write an opinion.
Yes,
You're both arguing. You want us to write to reverse, send it back. They want us to write to affirm. Would you both agree, however we come down on this issue, your trial judge said, oh, this is a case of first impression. And you seem to both agree there's no law in point. Would you both be in favor of certifying a question of great public importance?
I would, Your Honor.
I assume the other side is not nodding, but if you want to nod, you can. But I'm just gonna, for the sake of argument, I didn't ask them that. So maybe your judge was wrong. Maybe it's not a case of first impression. Maybe it needs elucidation. I don't know. That was my question. Now your time begins.
I'm happy to address that, Judge. We have extensively researched this. And there's actually, I believe, 2 states that have gone with our view on this with regards to how they see.
It's in your brief, the states.
Yes, I've got those sites.
That's okay. I can figure it out.
And as to your question, Judge Atkinson, with regards to the percentage of death which you were just discussing, there is a case right on point with regards to the facts
You
on
can
that.
sustain a cause of action for misinforming.
For misinforming, the
Let me ask-
percentage of death.
Right, okay, so
That's Bowers versus Talmadge.
you cited that.
It's in the brief, in our brief and their brief.
Okay, so, what is inherent in the proposed treatment? What is inherent? Why would the legislature put inherent?
Those are the risks that you're gonna have regardless of
What?
who does it and who the
Exactly,
patient
you
is.
said it, regardless of who does it.
Regardless of who does it.
So that's my question. How do I get around that? You just said inherent in the proposed treatment regardless of, wouldn't that imply that it's to isolate other variables inherent in the proposed treatment?
Those are the risks that every type of procedure like that's gonna have,
Right.
documented throughout.
So
the
why
country.
why do I infer the legislature intended to impose liability for not saying something that is, for not informing the patient of something that's not inherent in the proposed treatment, which is what you just said, which is inherent in the proposed treatment regardless of who performed it.
Well, it's like the Supreme Court discussed in the McCain case. It says this: the statute books and case law, in other words, are not required to catalog and expressly prescribe every conceivable risk in order for it to give rise to a duty of care.
But the type of risk, I know, we're talking about, yeah, that's what you allege in your complaint. We said, they didn't tell me that this risk was possible. But you just conceded that they did tell you the exact risk that
They-
unfortunately was visited upon your client. But I'm saying, why include inherent in what attended to the proposed risk hazards that are produced by the proposed treatment that are associated with, what does inherent in mean?
I think we just said what that is, what you would expect in every procedure.
Right, so where in this statute can I read into the statute a cause of action for failing to inform a patient of something that's not inherent in the procedure?
Because if you just step back a couple of words, it says the substantial risks. The
Inherent
substantial
in.
risks, which means the substantial risks in that particular procedure, because the Supreme Court uses words, as I pointed out, just before, it talks about the substantial risks under the circumstances. And they also use
So
that,
risks inherent in, so the inherent in has a different meaning or usage when, with relation to the word risks than it does hazards?
they use both of those words, and I don't think our legislature would have just repeated themselves.
Okay, so why does inherent in mean something different when you're talking about risks than it does when you're talking about hazards?
Because I think it's just, you and I talked about, those are the risks inherent, you're gonna have those risks.
So which one doesn't isolate variables such as
Substantial risks.
substantial
under
risks?
circumstances.
When you use the word inherent in with regard to substantial risks, that inherent in no longer means isolating other variables other than the treatment itself.
Well, the statute says.
Whereas
that-
it does isolate the other variables when
Yes,
you're
sir.
talking about hazards.
Yes, sir.
Why the distinction?
Well, because I think the Supreme Court I think the legislature in their infinite wisdom was wise enough to say, under the circumstances, not only in section 2, but also in section 2B, that they should look reasonably under all the surrounding circumstances. So what would that language, you have to read all of that together so that when you apply that to the term, the substantial risks, well, the substantial risk here was bigger. He created a bigger zone of risk. And as the zone of risk is created larger, then the duty is larger. So that's when the discussion should have been had between Dr. Papadopoulos and my client. I haven't done this for a while. Even Dr. Papadopoulos admitted in his deposition that he should have told him. Should have told him about it. So,
You got about 20 seconds to wrap up.
yes, I think you all have it. And I appreciate
All right.
your
Thank
service.
you, everybody, young people and old people alike, and myself. Have a great day. We're gonna take a short recess, okay, for about 10 minutes. We'll come back and do the last two cases.
All rise.
Thank you, Your Honor.